Yeah, just in case. Yeah.
Thank you.
Yes.
Greg Frank is now present finally.
Yes, we can hear you. Thank you.
Thank you for helping. I've never had that problem before.
Just let them know you're ready to start whenever.
And whenever you're ready, hearings officer, we can go ahead and open the hearing.
Okay, let's open the hearing, please. Are we recording?
We are.
Okay, thank you. We are on the record now. It's about 6:09, and the delay was on my part for not accessing the Zoom meeting appropriately, and I apologize. This is the time for the hearing for Deschutes County file number 247-23004009-A, which is an appeal of a decision made through files 247-22-000883-CU and 247-22-000884-SP. My name is Greg Frank, and I am a hearings officer in this matter, at least so far. Before we turn to the particulars of the hearing, I would like to turn things over to Planner Stewart to describe the electronic hearing process that we're involved with today. So, Ms. Stewart, the floor is yours.
Good evening, and I'm going to begin sharing my screen for a presentation. Bear with me for 1 second. There we go. For the record, my name is Audrey Stewart, and I'm an associate planner with the Deschutes County Planning Division. The item for the hearings officer is an appeal of a conditional use permit and site plan review to establish a guest ranch in the exclusive farm use zone. Today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at today's hearing. This will be followed by a brief presentation by staff on the application. The county has established time limits for testimony as follows: 30 minutes for the applicant, 20 minutes for the appellant, 10 minutes for public agencies, 3 minutes for the general public, and 10 minutes for the applicant's rebuttal. We do have a timer feature that will show up on the screen here in Zoom, and it'll be a clock that counts down. It doesn't make a sound when it ends, so staff or the hearings officer may remind you if your time is up. And the hearings officer may choose to modify or eliminate these time limits. The testimony portion of the hearing will begin, and the applicant will present first, followed by the appellants, and then any public agencies. And next, anyone in support will testify, followed by then those in opposition will testify, and last, anyone who is neutral to the applicant's request will testify. Afterwards, the applicant will then be awarded an opportunity to present rebuttal testimony, and finally, staff can make any closing comments. This is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please provide your first and last name, as well as your mailing address. For our in-person participants, if you wish to testify, please add your name to this sign-in sheet. I will use this list to call up participants for their testimony. After your name is called, please come up to one of the tables at the front here and give your name and mailing address before beginning your testimony. For our remote participants, if you wish to testify, you must be logged into Zoom or have called in to Zoom using the dial-in option. When hearings officer Frank asks if anyone attending remotely would like to testify, you will need to use the raise hand feature to notify staff. To do this, you need to press the raise hand button on your computer or smart device, or if you've called in, dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand it to me. If you're in person, please submit your written testimony to me after your oral testimony. If you're participating remotely, you can submit your written testimony to me via email, and my email address is here on the screen, audrey.stewart@deschutes.org. Hearings Officer Frank and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. Are there any objections to the format of the hearing? If you're attending remotely and have an objection, please use the raise hand function. Seeing none, I will turn the hearing back over to Hearings Officer Frank.
Thank you, Ms. Stewart. As Ms. Stewart described, we're following the normal hearing procedures set forth in the county code, and I will provide sufficient opportunity for everyone to participate at an appropriate time. I'd ask for your patience. To make sure we get through each of these steps as outlined. The application is being considered through a quasi-judicial process, and I will consider only the factual evidence that's in the record. I will then apply those facts to any relevant provisions of the county comprehensive plan or relevant land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing this hearing. They are set forth in the staff decision. The public notice and staff decision are posted on the county website. They are available directly from staff upon request. It's important that you direct all your testimony to the standards and the applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criteria. However, I urge you also to explain the criteria, why the criteria must apply, and to do so with specificity so that other participants, as well as myself and staff, may respond, and so that I can address your issue in my decision. The failure to raise an issue with enough detail to enable me or other participants to respond precludes your ability to appeal on that issue to the Oregon Land Use Board of Appeals. Also, failure to raise a constitutional or other issue related to any proposed conditions of approval with enough detail to allow me to respond to that issue in my decision precludes an action for damages in circuit court. As I just noted, I serve as a county hearings officer in this matter. In that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or interests of any participant in this case. To that end, I'd state for the record that I do not have any relationship with the applicant, and I'm not where I will disclose any relationships I might have with other participants in this proceeding that would prevent me from remaining impartial. My disclosures in this particular case is that I would note that Attorney Fancher and, if present, Attorney Isbell have both appeared in prior hearings that I have presided over and issued decisions. I can tell you that I have no personal, business, social relationship with either Attorney Fancher or Attorney Isbell, and I do not believe that having them appear in prior hearings impacts my ability to be an objective decision maker in this case. I do not have any ex parte contacts to disclose. It is my obligation to preside over this hearing in an efficient manner, and it would be helpful, and if you see my hand fly by, I apologize, but it's because I'm going up to my screen. I note that there are 7 participants, at least online. I don't know who FHC is. I am aware of Mr. Blackmore because his name shows up in this application. As I noted, I'm aware of Ms. Fancher, and I'm assuming Will refers to a county employee in the planning division. If someone else is present in the hearing room, it would be helpful if Ms. Stewart, you could identify those folks for me. If there's a large number, we'll dispense with this issue.
Thank you, Hearings Officer. Present in the room, we have the appellant, Rory Isbell, we have Greg Blackmore, we have Sarah Lee Lawrence, and then we have one person here to testify in support, Ashanti Samuels.
Thank you very much. I appreciate it. At this time, I'm going to ask whether or not anyone, that includes those present at the hearing room and anyone online, has an objection that I continue to preside over this case as the hearings officer and ultimately make a decision in this case. Does anyone object to my participation in this case?
Hearings officer, no one in person or over Zoom is raising their hand.
Thank you. Any final comments by staff before we get into the hearing particulars?
No comments.
All right, thank you. This will be the time and the place for the applicant or applicant's representative. If you're attending remotely, raise your hand if you would, please, and we will call on you. If you're in the hearing room and wish to speak first, let Ms. Stewart know. So I'll use Ms. Stewart to kind of shepherd me through this process of who's going to testify first on the applicant's behalf.
And just to clarify, hearings officer, staff does have a brief presentation on that subject application.
My bad. So this would be the time and the place for the staff presentation.
Correct. Thank you, hearings officer.
Sorry.
And with that, I will share my screen again and provide some background information on the subject applications. Okay, the subject property is located on Lower Bridge Way and Holmes Road. The subject property is comprised of 4 tax lots, which have a combined area of approximately 191 acres. The subject property and all neighboring properties are zoned exclusive farm use. The applicant proposes one property line consolidation and a subsequent property line adjustment. This will result in one 5-acre parcel and one 186-acre parcel. All 4 tax lots are involved in the property line adjustments, but the guest ranch approval is specific to the resulting 186-acre parcel, which consists of tax lots 100, 200, and 400. The applicant requests a conditional use permit and site plan review to establish a guest ranch. The guest ranch will consist of 10 cabins, which will each be 1,200 square feet. The subject property is developed with 2 dwellings and several agricultural buildings. The applicant proposes to convert a portion of the existing non-farm dwelling into shared space for customers of the guest ranch. A staff decision approving these applications was mailed out on May 9th, and on May 22nd, Central Oregon Land Watch filed a timely appeal. Issues raised in the appeal are summarized as follows: whether the guest ranch will be incidental and accessory to the livestock operation on the subject property, the impacts to nearby farm operations and whether they've been sufficiently addressed, whether the proposed design consists of more than 10 guest lodging units, the extent of the livestock operation on the subject property, and whether the applicant must identify the person conducting that livestock operation, whether the proposed site meets the definition of high-value farmland, and if food service is a required component of a guest ranch. Staff notes this hearing was originally scheduled for Wednesday, July 5th. The appellant alerted staff to the fact the mailed notice was not sent out in time to meet the 20-day noticing requirement per DCC 22-24-030. To avoid a procedural error, the hearing was rescheduled to Tuesday, July 25th. A revised notice was published in the Bend Bulletin on June 11th and mailed out on June 30th. Since the staff report was issued, the following additions have been made to the public record. The notice of intent to appeal, which was submitted by Central Oregon Land Watch, emails between staff and Central Oregon Land Watch regarding the new hearing date, materials submitted July 24th by the applicant. Staff has uploaded the hearings officer decision for file 247-18000-858A, which was an appeal of a prior guest ranch approval. The reason for uploading this is that sections of it were cited in my staff report. And finally, emails received from Central Oregon Land Watch at approximately 5 p.m. today were also uploaded to the record. All comments received as of 5 p.m. today have been uploaded to the public record, which is available on the link shown on this slide here. And with that, staff is available for any questions from the hearings officer.
I'm not sure it's appropriate to ask you now, or I can ask the applicant. But I did take an opportunity to review one of the earlier decisions. It were related to food service because it was referenced in one of applicants' later submissions. And I just want to make sure I understand the physicality of the or the geography. Was the prior decision with including property within the 186 acres, or is it a separate property? Is it an adjacent property? So if you could just kind of give me a picture of where that earlier decision geographically fits into this puzzle.
Thank you. I'll let the applicant speak to this. I believe they're more familiar with the area. It was the Pole Creek Guest Ranch, which is in close proximity, but not adjacent.
Okay. And then as a follow-up, there was a prior decision that was referenced in, I believe, Ms. Fancher's latest submission, as well as perhaps in the appeal issues regarding the food service and whether or not maybe it was related to the number of units, whatever. There was a prior, I call it the farm to table dining decision. How does that one fit within this whole context?
There was a 2021 decision for the property to the south, which is owned by Rain Shadow Organics, that Central Oregon Land Watch cited in their notice of intent to appeal. And I believe Attorney Fancher also cited in her July 24th materials. As of the argument for how that prior decision fits into their comments today, I'll let both the appellant and the applicant explain that.
Okay. And I appreciate that. Anything further from staff?
Nothing at this time. Thank you.
Thank you. This would be the time and the place for the applicant. And I already went through my discussion about testimony from applicant or applicant's representative. I'll allow Ms. Stewart to kind of direct who to the microphone or online who's going to testify.
Thank you, hearings officer. We have Greg Blackmore, who is here in person representing the applicant. And my understanding is that he has a presentation to share and will do a screen share.
Thank you. Mr. Blackmore, would you please identify yourself, first and last name, give us your mailing address, please?
Greg Blackmore Planning and Development Services. I'm at 19454 Sunshine Way in Bend, Oregon. Let's see, I'm going to go ahead and share my screen. Let's do this. Okay, I am muted, which is good. I want to be muted because I'm here and I'm talking into the microphone. Okay, let's go ahead and start the slideshow. Slideshow start. Here we go. Okay. So I'm here on the phone. Let's see. We have Sarah Lee here in person. We have Thai Engineering assisted with the site plan overall that's included in the record. They're not here, and Liz Fancher is an attorney who is on the call, and she will likely be jumping in with some comments after I'm done, potentially after I'm done, or maybe just rebuttal comments. We'll see if I miss anything, but I'm going to be initially addressing the submittal, the application, the proposal, and initially address some of the appeal items in my general planner ease, as opposed to the legalese that I'm sure Liz would follow up with. So I think we know the general location of the property. It's northern part of Deschutes County. If you can you see my cursor up there? You can see the cursor. The point of reference on this map is the city of Redmond. The northern Deschutes County boundary line is just north of the subject property. Let's see what we have here. The property is zoned EFU, Lower Bridge. And here's a general location of the property, the 186.26 acre unit of land. I think, let's see if I can see my notes on here. I don't know where I have my notes. I'm not a PowerPoint professional, so I'm going to go off my memory here. So the property, generally, as you can look at this property, you can see a lot, right? We have irrigated lands, primarily on the northern portion of the property. In this southwest corner, so I think there's 155 acres of irrigated land up on the kind of northern portion of the property. And that's generally where the agricultural uses occur. Down in the southwest portion, you have the ranch manager's dwelling, a series of farm and agricultural buildings, irrigation pond. This area that's kind of the farm use area has its own access point. There's an existing non-farm dwelling on the site in the south central area that is planned to be incorporated into the guest ranch development, in that a portion of the property will be used as lodge activities, or sorry, as the lodge. And then we have an unirrigated area. I believe it's about 9 acres or so over on this kind of southeastern portion of the site. And you had asked for a little kind of geographically where the Range Shadow Organics site is, and that's on south of Holmes Road, south of the property, south of Holmes Road. So it's adjacent to this property. And I can pull up a map here. I can pull up Dial and share my screen with Dial to share that with you if need be. So, general location, I have a couple arrows here that highlight the location of the lodge, and then the general vicinity of where the 10 guest ranch cabins are proposed. And this here is, I'm going to summarize the proposal a bit. As noted, there's 10 units. Guest ranch allow for up to 12,000 square feet of guest ranch units, and that's what is proposed here. The guest ranch is permitted to be up to 12,000 square feet, excluding the lodge. So we have proposed 10 units, 1,200 square feet apiece, which gets you to that 12,000 square foot allowance. The existing dwelling, a portion of the existing dwelling will be used as a lodge. The activities that will occur are passive recreational activities, interacting, walking the site to and from the lodge, the units to the lodge, observation of the farming activities, the ranching activities. I would note that no food services are proposed. There's no changes. This has its own access location. As noted previously, the farm use activities have an access point, and then the guest ranch will continue to use the access point that the current non-farm dwelling utilizes. Estimating what the guest ranch is anticipated to generate in income, it's anticipated to generate between $292,000. So that's a bit about the proposal. I think other things to note: that gravel drive is planned, paved walkway is planned. Each unit will have adequate parking. There's at least one parking space per unit, in addition to some ADA and other parking at the lodge area. You can look in here. This is kind of just a zoom in and a close up where you can see where the existing dwelling is, which will be used, portion of it will be used for the lodge. And then as you continue, continue over to the east, you get to where this gravel road will continue around for each of the additional 9 units, and a turnaround. I say 9 because there's this first slide here had the lodge and one of the guest ranch units. And this slide shows the remainder. Septic is planned. We've had some septic feasibility studies done. The site can accommodate septic. Well logs have been provided into the record. Overall, the application materials that have been provided initially, we have some application forms, a detailed narrative, some deeds, site plan. There's a traffic report. There's some architectural plans that have been included into the record, will serve letters, well logs, septic evaluation results, and the owners have an agreement with Cloverdale Fire District to provide fire services to the site. So a big part of, well, an integral part of a guest ranch is that it can operate if there's an existing livestock operation. So it's important to understand that there is indeed an existing livestock operation. As noted in the record, there's the ranch operates, there's 200 mother cows, 20 bulls, 200 calves per year, which equates to 420 head of cattle in a given calendar year. They keep the cattle until they reach butcher weight. They sell 100% direct as local beef, sell approximately 80,000 pounds of beef per year, and generate income of approximately $560,000. There's also stables of working horses that work on the property year round. It's a great operation. They're proud of the work that they do. It's a sustainable, environmentally conscious ranching operation that benefits our community. And we can look at the bullet points, but if we want to prove it above and beyond our bullet points, we can have some photos here in the slides. Here's some images of the cattle. Here's some images of the equipment that's utilized. We have some images of some activities that happened on the site, and these are all from this. These are all from the ranch operations. These are that were taken on site. Here's some pictures of branding operations that occur. Here's the people who work the ranch. Some, not all, but some of the people who work the ranch and assist with the operation. So there's a great existing livestock operation that occurs on the site. As I was preparing this PowerPoint presentation, I didn't go through every individual approval criteria, development standard and approval criteria. There's a well-written, there's a well-documented record that addresses that. We have our narrative that's included in the record. We have staff report that addresses the majority of these. So just highlighting a handful of general standards and criterias to make note of, and rather than going item by item by item. So, in general, we have to prove that this guest ranch operation will not force a significant change in accepted farm or forest practices, and it won't significantly increase the cost of accepted farm or forest practices. So we have a rather extensive documentation in the record proving where the traffic impacts are limited. There's adequate distance and just buffers, distance and native vegetation buffers that this development or the guest ranch is not located on any farmable or irrigated land. And overall, the recreational activities, it's not a high intensity recreational activities like things that are going to generate a lot of noise and sounds and dust or any other potential impact. So as you will see through the record, the impacts are minimal and will not impact farm or forest practices or increase the costs. Generally we have to prove that the actual site on which the use is to be located is the least suitable for production of farm crops or livestock. You can see this image here, which is an aerial view. There's areas of the site that are irrigated and have good soils, and they're used for farming operations. And in this farm, as you can see, the farming operation is successful. And if there's additional areas that could also be useful and successful to enhance that farming operation, they would. But this area is not. It's used. It's approved for a non-farm dwelling. It's not irrigated. The soils, as noted in the record, they're not. It's not high value soil, and so this area, the actual area, the site where this guest ranch is proposed, is indeed the least suitable for the production of farm crops on this property. aside from that, just working through general standards and criteria that apply to a guest ranch and a site plan and a conditional use permit. There's standards related to setback and height. There's standards that relate to parking and bicycle parking and exterior lighting, service drives, clear vision areas. Those are generally not disputed. The records, it documents all of compliance with all those standards very well. So I'm not going to dig into those particular provisions any farther, unless, of course, you have any questions. Then aside from the general criteria, there's also the specific, the site plan criteria, provisions that the use needs to relate harmoniously to the natural environment. There's specific landscaping requirements, there's access and accessible route requirements, drainage requirements, buffering, screening, utilities, and transportation. Again, similarly, these are items that are included in the record. The use being a low impact guest ranch where folks are anticipating interacting or being close to livestock operations. There's not conflict on the site and amongst the site between that use and the farming operations. The livestock operations are a critical component of and necessary for the guest ranch. And so some of the other items, accessible routes, those are things like locations and widths of routes. Those are all pretty straightforward and proven to be met on the site plan and not disputed. In terms of the conditional use permit criteria, we need to prove that the site is suitable for the use. So a critical component of the site being suitable for the use is that there's a livestock operation there, which I think we've pretty well documented. There's one that's there, it's good, it's successful, and it benefits the community. Aside from that, the site of the guest ranch is located in an area, we can go back to that aerial image, but it's in an area that there's no irrigation happening. There's poor soils, and it's still far enough away from neighboring properties that the structural development is far enough away from neighboring properties that there's going to be limited impacts and screening. And of course, other potential impacts, of course, would be transportation, and as noted through our traffic engineer, the number of trips that are generated are minimal, and the abutting roadways have more than adequate capacity to accommodate those trips. Let's see. Natural and physical features of the site. The development, there's a specific size allowance for guest ranches. And so that is what has been proposed. 12,000 square feet are allowed. And there's 12,000 square feet of guest ranch units that are proposed, and they are proposed in separate units. So it's not there's an ability to locate in the units around the site within the farmable area to adequately preserve natural and physical features of the site. So it's not like you have to come in and blow up a rock wall or something, or a rock outcropping in order to put a 12,000 square foot bunkhouse. Instead, we have a series of small units that as you can see, they're oriented along a roadway that utilizes and works with that existing topography, natural features of the site. And so it indeed limits those impacts to those natural features. And then we just get into compatible with existing and surrounding uses. Indeed, the site is large, 186.26 acres. The surrounding area has, farming, livestock operations occurring on it, which are, a guest ranch being allowed within this zone is a use that's compatible with those sorts of operations. Overall, the guest ranch itself conforms to the established size and scale standards. The recreational components of the guest ranch are extremely limited and passive. And of course, the location of the structures have been situated, set back from surrounding properties, such that there's adequate buffering and screening. And then let's see, and there's a series of specific guest ranch requirements that some are clearly met and some of those are disputed. So here's a few slides addressing the appeal items, which I'm going to make a quick note of them, and I suspect that Liz would jump in and either correct me if need be, or add to anything that would be needed. So one of the items that was appealed was that the guest ranch is occurring on high value farmland. Liz has provided some additional documentation, a definition, and a map that clearly show that the guest ranch is not on high value farmland. Let's see, there's an extensive discussion here about incidental and accessory to economic, incidental, that the use is incidental and accessory to the guest, to the livestock operation. What Liz points out is that additional analysis, she knows that economic value is something that can be considered, but it's not controlling in determining whether or not. So, and again, focusing on economic value, her comment is that economic value may be considered, but it's not a controlling factor. There's other things that are likely more important, and those are the size, the scale, the intensity, and the use of the site on whether or not this guest ranch is incidental and accessory. Above and beyond that, she goes on to point out that the guest ranch is forecast to generate less income than ranching operations in the event where that economic, to address economic value just as another approach. Let's see, there was a conversation about the need to modify or alter that neighboring land use decision. To modify that neighboring land use decision, they are indeed separate sites, they're separate uses, and they're not linked. It's not the same property. It's a separate property. The uses are different and the site is different. And then there was a question about, or Liz provided some additional evidence, a very thorough assessment of surrounding properties. It's included in the record. I don't know what the size, I believe it was a 1 mile radius around the site that was analyzed of the surrounding properties to understand, to provide additional evidence as to whether this use would impact surrounding farm uses. So there's additional analysis of what the surrounding uses are and what the farming activities are to understand whether or not there is any impacts to them or could be potential impacts to them. An issue related to number of guest lodging units. There's a specific unit allowance and a specific size requirement, both of which are met. And so that was a discussion of whether or not, these individual cabins that are considered a guest ranch unit. I forget what they're called, actually, probably a lodging unit, whether or not those would exceed whether or not those would exceed what can be permitted. And so Liz went on to provide additional information and documentation of why those individual units, like I said, meet the unit allowance, conform to the unit requirements, meet the unit allowance, and meet the overall size requirement. Arguments related to, or appeal items related to whether or not there's a livestock operation on the property. I think we've addressed that adequately to date. And Liz provided some information about the ranch operator, which was an item on appeal. And then in regards to food service, Liz points out that food service is something that's permitted, but it's not mandated. In this particular case, food service is not proposed. And Liz, if you have any other thing you want to add, please, allow her to jump on.
I believe Liz has been raised to a panelist, so she can unmute herself and start her video if she'd like to chime in.
Ms. Fancher, before you going with your testimony. Would you identify yourself for the record? First, last name, give us your mailing address, please.
Okay, my name is Liz Fancher. My mailing address is 2465 Northwest Sacagawea Lane in Bend, Oregon, 97703. I don't need to testify at this point in time. I'm intending to provide brief rebuttal comments related to Mr. Isbell's testimony. We addressed as best as possible the issues that were raised in their notice of appeal, which were rather scantily described, and provided additional evidence to support approval of the decision. So that information is all placed in the record. It was filed yesterday. Includes a chart that describes all the area, farming practices, and potential impacts, includes an impact analysis for all of the properties within a mile of the subject property, which is a far greater area than will actually be impacted by this particular use, which is actually a fairly low impact use of land. I know the hearings officer is asking questions about other properties. I don't know exactly which ranch operation you were referring to initially, although maybe Pole Creek Ranch, that's located outside Sisters on the other side of Sisters and has nothing to do with this case. It's a completely separate matter, and it's an approved guest ranch. The other matter, the food service, is located south of the subject property on the other side of Holmes Road. And it is owned by Lawrence Farms, LLC. And it is used and operated by Rain Shadow Organics. They have a commercial activity in conjunction with farm use to conduct a small number of meals, to offer farm to table meals on a few limited occasions. In August, they're going to have 2 of them a month. They can have more than that under the terms of their permit, but it is a very low intensity use of land. They also have a small farm store, and they produce farm products on the product. They process farm products of various and sundry types. So other than that, I don't have anything else to add, and I'll wait for rebuttal.
Thank you, ma'am. I
Thank you.
appreciate the testimony. Anyone else wishing to testify in support of the application? On behalf of the applicant.
Would anyone in the room also be testifying in support on behalf of the applicant? No one in the room is indicating that they're also testifying with the applicant.
Anyone online?
We have 4 online attendees. I'm not seeing any raise hand features. So as a reminder for our online attendees, if you are also testifying with the applicant, please raise your hand at this time. Hearings officer, no one online is raising their hand.
Okay, thank you. As Ms. Stewart indicated, she asked for additional folks who wish to testify, and I'm going to take it as there is no one else on behalf of the applicant wishing to testify. So I'm going to move on to the opposition. Mr. Isbell, on behalf of the appellant, I would grant you the right to go first, if you'd like.
Yes, thank you, Hearings Officer Frank. For the record, my name's Rory Isbell, representing Central Oregon Land Watch. Our address is 2843 Northwest Lolo Drive, Suite 200, Bend, Oregon 97703. But before I begin, Audrey did mention earlier that we did submit some additional testimony earlier today. I have a couple of printed copies. I'm going to hand one to Audrey and one to the applicant here before I begin.
Mr. Isbell, if I could interrupt before you get started, I just want you to be aware that I've reviewed the record up until what I think you just handed in, but I've reviewed the record rather cursorily, if there is such a word. But I have, in other words, I haven't studied it in any great depth, but I have taken a look at it. That includes your notice of appeal and that particular document. But I have not seen the document that you're referring to today. So you're aware, I have reviewed I think it was yesterday, July 24th document from Ms. Fancher. I did go through that on a fairly cursory basis, but I am familiar with what's there. Obviously, if I'd gone through it in greater detail, I'd realize probably that the one property was across the street from this particular property. But that's why we have hearings, and that is to make sure that I have a full understanding of what's going on. Final comment that I'd like to make, and it's not included in my opening comments, and I probably just didn't say it and should have. If anyone wishes to keep the record open following the conclusion of today's oral testimony, they have a right to ask for the record to remain open. And if someone does make such a request, we'll talk about those logistics at the end of the hearing. So with that, Mr. Isbell, you may proceed.
Okay, thank you, Hearings Officer Frank. I appreciate the extra information there, but before I jump into this, thanks again for hearing testimony tonight. Landwatch is opposed to the administrative decision that approves this guest ranch in the county's exclusive farm use Lower Bridge subzone. A couple general words to start. Central Oregon Landwatch is a big advocate for our state's land use system. And a core part of that land use system is Goal 3, which preserves lands for agricultural use across the state. Our statutes and rules that implement Goal 3 do permit a number of non-farm uses, but they are strictly regulated. There's a lot of both statutory, rule-based, and case law criteria that apply to non-farm uses. And it's really looking at that, comparing the goals of the land use system to promote farm use of farmland with the number of non-farm uses that are allowed yet strictly regulated. That kind of brings Landwatch here to be involved on this county administrative decision tonight. So just to be clear, Landwatch is strong supporters of farming and ranching in Deschutes County, including livestock operations. But to sort of jump into some of the details here, there are a number of criteria that apply to the conditional use of a guest ranch on exclusive farm use land. These criteria primarily come from statute, and they are also implemented locally in the county code. There's sort of two main sections that impose criteria. There's DCC 18.16.037 and DCC 18.128.360. Some of those criteria overlap a bit, but I am going to walk through them sequentially to sort of explain the points of this administrative decision that we do disagree with. Starting with the definition of a guest ranch at 18.16.037B. There's really two elements of that definition that we do raise as issues in this administrative decision. The first is the provision of food services. It's really part of the definition of a use of a guest ranch that the facility include food services. We believe the decision here errs in approving a guest ranch that states it does not provide food services. Now, there's a related criteria to this that I'll talk more about in the next set of conditional use criteria. But sticking with this definition of guest ranch, it's also where we see the terms incidental and accessory, meaning that the commercial use, the guest ranch use, must be incidental and accessory to the existing livestock operation. Our qualms with the decision here is it seems to really base its findings on incidental accessory on one factor, which is the size, the area of the two uses that are being compared here, the guest ranch use versus the livestock operation use. There's case law interpreting this language, although we admit for a different non-farm type of use, but it seems that the same legal analysis should apply to the same language used elsewhere in the EFU statutes. But it requires an analysis not just of the size, but of the nature, intensity, and economic value of the farm use proposed to the commercial use. That's a Court of Appeals case, Friends of Yamhill County v. Yamhill County at 301 ORAP 726. So we didn't see that analysis here in this administrative decision. And related to the incidental and accessory standard, we do raise the issue of the neighboring property across the street that has an existing commercial activity in conjunction with farm use permit attached to it. So in that county decision, there's a condition of approval that limits commercial income as a function of the farm income produced. Again, to ensure that that's the same standard of being incidental and accessory is met. And in that decision, I should state it, this is Deschutes County file number 247-21-00268-CU. Condition of approval L lists the subject property tonight as one of the farm properties where income is garnered by which to balance the commercial use income against. So it seems like by not addressing that in the current decision on the guest ranch, there's a bit of double counting where we are using farm income from both properties to justify two different commercial non-farm uses. And as we did note, if that needs to be amended, then there are somewhat procedural requirements that have to be addressed to reopen that decision at ORS 215416. The next of the county's criteria that we raise is the definition of a guest lodging unit. The county code at 1816037C defines a guest lodging unit as a guest room in a lodge, bunkhouse, cottage, or cabin used only for transient overnight lodging. Here, the decision approves 10 1,200 square foot cabins, but we didn't see how the decision finds that the limit of 10 guest lodging units is achieved in that approval. And this is another situation where there are somewhat overlapping criteria in these two sets of conditional use criteria. So I will touch on that point again in a moment. Speaking of moving on to the next main set of the county's conditional use criteria, starting with DCC 18.128.360A, this criteria does require that the guest lodging units cumulatively shall include not less than 4, no more than 10 overnight guest lodging units. That, of course, that language mimics the definition I just talked about. It's unclear to us in this decision how a 1,200 square foot cabin includes only one room, which is what a guest lodging unit is defined as. So we didn't see clarity in the decision on that point. And we also want to raise that, we saw in this administrative decision the imposition of a condition of approval requiring that the non-farm dwelling that's part of the subject property shall not be used as a short-term rental or vacation rental without first obtaining any required land use permits. It does appear that this non-farm dwelling on the property is being used as a short-term rental. We do include with our written testimony submitted earlier today an exhibit that shows the listing for that short-term rental use. And we wanted to note that there is a recent Court of Appeals decision, 1000 Friends of Oregon v. Clackamas County, 320 ORAP 444, that finds that short-term rental use on resource land, so farm and forest land in the state is not allowed under our Goal 3 and Goal 4 statutes. Next criteria at DCC 18.128.360B2 requires that the guest ranch is located on a lawfully established unit of land that contains the dwelling of the person conducting the livestock operation. The administrative decision here approving this use doesn't identify who the person conducting the livestock operation here is. it's our position that without knowing that, it's really impossible to find whether this criteria is met, whether that person lives on the same unit of land here. DCC 18.128.360B3 is the high value farmland prohibition. You've heard that the subject property here does include a fair amount of high value farmland. But digging into the county's definition of high value farmland, it defines it as find my text here so I don't misstate it, as land on a tract. So it uses the word tract, and the county separately defines tract as meaning one or more contiguous lots or parcels in the same ownership. The county further defines ownership. So we raise the issue here because it appears that it's likely that the tract that we're talking about consists more of just the subject property because of affiliated ownerships of other properties in the area. We also attach as an exhibit to the comments we submitted a previous county hearings officer decision that interpreted this tract and ownership issue. It was for a different type of use. It was for a farm dwelling or a dwelling in conjunction with farm use and not a non-farm use that we're considering tonight. But the same issues apply. It requires determining the extent of the tract at issue before we determine whether it's predominantly high value farmland. And again, we didn't see the staff decision here examine the extent of the tract. The next criteria is DCC 18.128.360E. This is another food services criteria, just in a different part of the county code. It states that food services shall be incidental to the operation of the guest ranch and shall be provided only for guests of the guest ranch. We believe the decision errs in approving a guest ranch that does not include food service. A subsection of this criteria prohibits the sale of meals to any non-guests. Now, of course, as we've discussed a couple times already this evening, a couple of years ago, the county approved a permit for the adjacent property across the road for this applicant to serve meals to guests of that property. So because that property serves meals to folks who are not guests of a guest ranch, the guest ranch criteria tonight prohibits serving of meals on that property to those guests. And conversely, if that adjacent property would serve meals to guests of a guest ranch, then it's our position the guest ranch criteria here prohibits that property from also serving meals to non-guests of a guest ranch. So it's a bit of an inverse, but it seems that it has to be one or the other because of the language of the guest ranch criteria issue here, how it says that the ranch may not serve meals to non-guests. The sort of last substantive point we raised is the farm impacts test, which is from statute RS 215296. The applicant described it earlier. It's implemented locally at DCC 18.16.040. The administrative decision here didn't describe with adequate specificity the nature and the character of farm uses on nearby properties. And without that information, it's really impossible to determine the impacts that this non-farm use might have on those farm properties. Now, I believe, heard tonight from the applicant, there's now more materials in the record addressing this criterion. I haven't seen those. I saw something was uploaded earlier this afternoon, but I was not able to dig into it. But our point remains that the approval decision that's at issue tonight does not adequately address those farm operations in the area or posit what impacts on those farm operations might be due to the non-farm use approved here. So that really wraps the issues that we wanted to raise tonight. I'm going to restate that Landwatch is thrilled to see a budding livestock operation in the Lower Bridge Valley. The Lower Bridge Valley is one of the most agriculturally productive areas in our county and in our region. Our issues are really related to ensuring that the criteria for a non-farm use of farmland are met. It's a high standard, and we want to see those standards met. You mentioned at the outset of my testimony, Hearings Officer Frank, to be sure to remember the open record period. I think before you logged on, there was some discussion in the room about who has vacations coming up. I was one of the people who raised my hand. I'm out all next week, so Landwatch would request that we leave the record open, and preferably for 14 days to handle the couple of vacations that we heard about that folks have this summer. That concludes my testimony. I'd be happy to answer any questions you might have for me before I step down.
Thank you, Mr. Isbell. I don't have any specific questions on most of it. And I've tried to emphasize in both in this hearing and other hearings you've attended that I try to come into these hearings with as open a mind as I possibly can. I try to review the record, at least on my word, the cursory basis to at least be familiar with most of the things that are going to be raised. But I certainly don't dive into those issues and try to understand them sufficiently as to make a decision without first hearing you and anyone else who wishes to testify. With that as background, the only question I have, and you don't need to answer it right now because the record's going to remain open. I have no ability to say you're wrong. You can't have that. So the record will remain open. It's just a matter of how long, and we'll talk about that at the end of the hearing. But the only issue I have is and it's maybe just more common sense than anything else. I got a land use decision that I now know relates to a property just south of the property that we're talking about here. And I'm having a hard time intellectually at this point in my understanding of how a decision to the south is to be treated in essence as part of the approval criteria, which it really amounts to, is what you're telling me, is that it is the approval criteria, specific approval criteria aren't met because there is another decision on a not included property that in fact is going to have an impact in this particular decision. It's a common sense sort of a question that you may have addressed in your written materials. I promise, as always, that I will read them. You don't have to answer now, but that's a fundamental question that I have. If I can't get over the hurdle that it's a separate decision that doesn't really have any impact here, everything you said about food service back and forth towards the end is really irrelevant. And I'm not saying it's irrelevant. I'm just telling you that's my common sense first impression at this stage. So if you want to talk about it right now, you can. If you want to put it in your written response, you can. I'm leaving that option open to you.
Sure. Thank you for the question. The reason we raise that prior decision is really because of a condition of approval that it includes. And it's quoted in our written materials that we submitted earlier today. And it's condition of approval L.
And Mr. Isbell, I'm looking at it right now. I have it right in front of me.
Okay, great. So you see in that condition, and again, what this condition does is it limits the amount of commercial income compared to the amount of farm income on that property. But it defines what constitutes farm income, essentially. And it includes in that definition of what farm income is, it includes the livestock operation on the subject property tonight. So the farm income attributable to the subject property tonight is already being used to balance commercial uses against farm uses on that neighboring property to the south. Does that hopefully help you understand why we believe that's a relevant piece of information?
I'm not sure I agree with it yet, and I don't have to make that commitment yet.
Sure.
But I do understand what you said, and I will look at especially the first 2 or 3 lines of condition L. It seemed to be most relevant. But I appreciate your testimony. Anything else, sir?
No, not this evening. Thank you so much.
Okay, thank you. Anyone else in opposition who wishes to testify tonight, either in person or online? And Ms. Stewart, you can help me out there.
Hearings officer, I don't see any hands raised on Zoom or in person. If it's okay with the hearings officer, I'm going to double check with in person. I did have one person who had been signed up to testify in support. And I'm not sure if they had still planned on testifying. They're indicating no. So I don't see any hand raised in Zoom or in person.
All righty. If there's no additional opposition, to me, the county's most interesting provision in their code is there anyone neutral? I find that to be an interesting concept. Don't find very many people testifying on that, but is there anyone, Ms. Stewart, that's neutral?
No one on Zoom or in person is raising their hands, hearings officer.
All right, thank you. Is there anyone, does the applicant wish to take their opportunity for rebuttal?
Greg Blackmore is in person and he's indicating that yes, they would like to provide some rebuttal testimony.
Have him take a seat, please.
We'll offer it up to Liz, who would be planning on providing any rebuttal comments. So Liz, if you can elevate Liz to a panelist and she can address that.
And Ms. Fancher, as you're doing all the little button pushing that you do to get access, would you do me a favor at the end of your comments, talk about the open record period, and I'm going to ask the same of Ms. Stewart.
Okay, certainly will do that. I'll even start with the open record period, just so you know, we would ask for the open record to remain open for 7 days post hearing comment period. Not in favor of 14 days. So, responding to the arguments that were made by Landwatch, I think generally, I think we agree with Landwatch that the decision can be beefed up with more robust findings, and we'll try to provide that information to you in future submittals. You know, we've provided you the raw material to do that in the material that I filed on Monday, and we'll provide you with draft analysis and argument that you can consider and possibly utilize some of it in your decision. The main issue that I think, you know, Landwatch does have a reasonable point on is the incidental and accessory test. It's a fairly involved test, and I guess the case that Landwatch is relying upon does not use the exact same words that are in the guest ranch law. They're not exactly the same words, but I believe they're essentially the same test. So we agree with them on that, and we believe that Landwatch has not necessarily fully indicated all of the considerations that can be considered when you look to determine whether use is subordinate or predominant use of land. It says that there are many relevant factors, and they include the nature, intensity, and economic value of the respective uses. So those things are a part of it, but they're not the only thing. None of them are. And then other comments that are made in the same case that's relied on by Landwatch are that really what's important is the intensity of the use and how it impacts the land. So the nature and intensity of the use, we believe, were addressed by the staff report. We didn't really address the economic value very much. We had hoped that Landwatch would support our application because it supports continuation of farm use on this property, that the two uses function well together and support each other and make it more likely that a farm use will continue to occur on this particular property in the county. We want to have thriving agriculture in this county that has a dismal record of farm operations losing money. About 84% of the farms in the county, according to the 2017 U.S. Census of Agriculture, lose money of gross income. They do not make gross income out of their farm operations. So they spend more money producing a crop than they make from selling the crop. So in this instance, we have a farm operation that works, that makes gross income, and we would like to see it continue in the county. Mr. Isbell's indicated that the Lower Bridge area is a prime agricultural area in the county. That's true. This particular property is at the northern end of Lower Bridge, and it is not an area of prime agricultural land. It's where the land starts to transition away to rangeland that's further to the north. Landwatch's arguments that I read just very briefly that were filed just tonight indicate that they basically want you to look at everything along the whole area. They want you to consider the guest ranches being operated on the property of the south. They also want you to consider it being operated on leased land. The guest ranch itself is proposed for a specific piece of property in a specific location. That's the subject property. That's where the guest ranch is going to be. That's the land that was shown to you by staff and by Mr. Blackmore. It's not the land that they lease. Leased land for cattle operations can be numerous locations depending on where they are located. So Mr. Isbell has argued, oh, gee, we have to prove that the guest ranch leasing won't occur on certain types of lands because you can be operating a guest ranch there. And if you look at the definition of a guest ranch, the guest ranch is defined as a place that has lodging on it. So I think it's an absurd interpretation. And I think a lot of these arguments that are in the most recent submittal are a real stretch and are not credible arguments like the incidental and accessory argument, which is a reasonable argument to present. We think that it's very clear from the actual facts of this case that the operation of the cattle ranch is the dominant use of this property, and that the guest ranch would be a supportive operation. The idea for by the farm is to open the guest ranch to members of the public so that they can observe the ranching activities that are being conducted in an environmentally friendly manner on the property. The property owner is working to put the land into a land trust so that it will be protected for all time for agricultural use. They're sincere in that desire to keep the property in farm use, and they are even abandoning the use of their cross fencing. They're taking out cross fencing to allow greater use by wildlife, and the cattle basically have invisible fence collars on them to make sure that they lower their impact on the land. So they do a number of other things in addition to transitioning their property over to organic farming methods so that the property will become an organic farm and can be certified as such. So they want to educate the public about those processes, and they also want to raise awareness of their beef products so that there will be demand for them within the local facilities that purchase the beef from the ranch. The Rain Shadow farm, or not, they're not, Rain Shadow Organics does operate their or grow their crops on the property of the south, on property owned by Lawrence Farm LLC. And they have a very good reputation in the community for being successful farm operation for organic farming that have sort of beaten the odds. They improve the land because the land where they farm is not good farmland. It is not high value farmland. And it is not high value farmland for the reason that Landwatch asserts that that property to the south is farmland, and it's not a part of a tract with that property. The 2T and the Lawrence Farm properties are not a tract. They are not owned by the same owner. The materials filed by Landwatch quote the definition. The definition is clear. The legal case that was included by Landwatch, although it's not posted online, I believe is a case that is wrong and has not been followed in other county decisions. And it related to basically said that a trust, if someone has a trust, a personal trust, I believe, on property, if I'm remembering correctly, is the same as the individuals who own the property next door. So they hold their land in a trust, and a trust is a very special relationship that is very different than corporations or LLCs anyway. So it's absolutely clear that these properties are not a tract, and that tract analysis would not apply here. So, and then the food service thing, it's really sort of ironic that I sort of beg my clients to propose a guest ranch that is very minimal, so that my hope was that Landwatch would support the application because it is so minimal and it's much less of an intense use than those that occur on other guest ranches that they have opposed. Have worked with Landwatch on other applications and learned their main concern in those cases were events, and we offered absolutely no events here, and we offered no food service as a means of absolutely being certain that the use would be incidental and subordinate, and that it would be clear that we're not going to be operating a event facility here, and that it would just be for the purposes of lodging. You know, to the extent that it's absolutely required to have food service, we just believe it isn't. So we'll address that further in further comments, in post-hearing comments. There's one other point. Oh, the dwelling issue. I don't understand how the name of the person who is the ranch manager makes a difference. People change, ranch managers change. The people who are going to run the farm operation or the ranch operation are going to change. And the farm manager is the farm operator for purposes of the statute. They're one and the same. They're going to conduct the livestock operation. The farm manager is going to do that. So to the extent that we believe that should settle the issue, I don't understand why their name is relevant, and it can only, in my mind, create confusion in the future when the ranch manager changes. It's not a permit personal to the to that particular person.
And just so you're aware, Liz, you have about 20 seconds.
Okay, I'm done.
Thank you. I don't have any questions at this time. I'd like to, at this point, go to Miss Stewart and ask the county's perspective on the open record period. I don't know who Mr. Isbell was talking to about vacation, so I'm left out in the cold a little bit. So if you can respond to that, I'd appreciate it.
Thank you, hearings officer. There are no county staff vacations that would preclude any different open record period. It sounded like between the applicant and the appellant, there were some vacations that were talked about, but on terms of the county end, there's no preference. So,
Okay, thank you. So the
and hearings officer Frank, do you have a slide going over the requirements for the open record period, just for the benefit of everyone here? And I can do that either before or after we decide on what the open record period will be.
let's do that afterwards. I was just trying to pull up, there we go. I was just trying to pull that up and have found it. And I would prefer that you go over it. Right now you have August 1st, August 8th, and August 15th as the dates that you're suggesting would be an appropriate open record period. Is that acceptable to the county?
That's acceptable to the county. And to clarify, those dates were added if the hearings officer decided to go with the 777, which is a fairly standard format. Those dates were provided for reference.
No, I understand. That's why I wanted your approval of it, because I knew it was meant just for discussion purposes. The county does not object. Ms. Fancher, you want to get back in here real quick? I already know Mr. Isbell's preference, so I just want your approval of the open record period. Ms. Fancher?
Yes, hi.
Oh, I
Hello.
thought you went to dinner, so.
No, not yet.
All right, is the August 1st, August 8th, and August 15th acceptable to the applicant?
Yes, it is.
Okay. With that, and by the way, Ms. Fancher, before you go, and I don't mean this as slighting anyone, but I just have to note that I have heard the comment, you need to beef up the findings in past cases, but actually never before has it been relevant to the application in any case, since we have a cattle operation here. So I compliment you on whatever that is. It's not double entendre. It's clever. So I like it. And many things passed by me, but that one didn't. All right. So with that, then I'm going to talk about the open record period for those who are either listening, watching, present at the hearings room, or will ultimately view the video recording. The open record period means that the case doesn't stop tonight. The record of the case does not close tonight. What it means is that the oral portion of the testimony is done, but what isn't done is the opportunity to submit additional information. The record will remain open for the submission of new or whatever evidence you want until Tuesday, August 1st at 4 p.m. The record will remain open for the submission of rebuttal evidence. And I'd like to emphasize that rebuttal evidence means that it's in rebuttal to what came in during the first, at least my perspective is what came in during the first open record period. So in other words, what came in by August 1st. If you disagree with that and want additional evidence on the record to respond to that, then submit that evidence into the record or that argument into the record by 4 p.m. on August 8th. That basically, those two record periods talk to anyone who wishes to submit evidence. The final period of time, which ends on August 15th at 4 p.m., is only for one group, and that is the applicant. And so the applicant has the ability to submit their final argument on or before 4 p.m. on August 15th. So I would request that if you don't agree with my characterization of the first and second open record periods, you can certainly comment on that during your submissions. But it makes the process work a lot smoother if whatever you want to do to submit into the record, you do by August 1st. Whatever you do between August 1st and August 8th is in response to what came in during that open record period. And finally, anyone other than the applicant has no right to submit anything after August 8th. August 8th to August 15th is only for the applicant's final argument. I'm not sure it's relevant, and so I'm not suggesting anything beyond. It's hard for someone in my position to 100% forget everything that they've done in the past. Recently, I have had a case that dealt, I believe actually was in Bend, but it may have been in Deschutes County, with respect to, no, it must have been in Deschutes County. It was a lavender farm. And the lavender farm decision that I made, it wasn't Deschutes County, did relate to a specific portion of the code, but also related to the incidental and accessory concepts. I'm not saying it's relevant, but I'd like to disclose that I have at least addressed in some respect those concepts. And if I was wrong in those in the earlier decision, you can certainly comment on that, but you might want to look at it. If you don't know what that is, my guess is Ms. Stewart can address you or forward you to the appropriate decision. like I say, I don't know if it's relevant. I'm not considering it. I haven't looked at it before this case. I try to conveniently forget whatever decision I've written unless it's appealed within a day of issuing that decision, so that it doesn't taint earlier or later decisions. But you may wish to look at that. Anything further from the county?
No additional comments, and I do, whenever the hearings officer is ready, I do have those reminders about the submittals during the open record period.
Please give those comments now.
Thank you, hearings officer. I'm going to go back to sharing my slides very briefly. For the open record period, please keep in mind that all submittals should be addressed to me. And for email submittals, use my email address, audrey.stewart@deschutes.org. The county does not retrieve information from a website link or personal cloud storage device. It is your responsibility to submit all evidence and testimony you want the hearings officer to consider. Any electronic submittals must be received by the county server by 4 p.m. Please do not wait until the last minute to submit your evidence and testimony. And for the benefit of everyone here are the dates that were agreed upon. So new evidence and testimony can be submitted up until 4 p.m. on August 1st. Rebuttal testimony can be submitted up until 4 p.m. on August 8th. And then the applicant's final legal argument will be due by 4 p.m. on April 15th. And with that, staff has no more comments. August 15th, yes.
I'm sorry, I missed the last comment.
Oh, I think I misread it the first time. So the final legal argument is due by 4 p.m. on April 15th. Oh, August 14th.
I don't think it's April. It's August 15th.
Yes.
Oh, all right. I appreciate the correction because that could save us all a lot of anguish in the long term. All right. With that, then I want to express my appreciation to both the applicant, the speakers on the applicant's side, the testimony of Mr. Isbell, which is always appreciated, and the professionalism shown by Ms. Stewart in this case. It makes the process go more respectful and more pleasant. And not that hearings necessarily are always pleasant, but being respectful is always appreciated. And I think you all did that today. With that, we will close the public hearing, except for the open record period, which has been described in the numerous events. Thank you. We'll close the hearing.